Hello, everybody. This is Chris Addig with the Veterans Law Blog, and I'm here today to try a new way of sharing information with you. This is what I'm going to call a screencast. What I'm doing is I'm recording my computer screen as I walk you through some different things. What are we going to talk about today? Today, we're going to talk about how to read a statement of the case. Now, what is a statement of the case? Statement of the case is pretty far into the appeal process where you're appealing to the board. And so what I've got up on the screen right now is one of my blog posts where you can read about those overall steps and we can see where the statement of the case fits into the claim. So first you file your original claim. The VA either grants or denies that claim and you get a VA ratings decision. If you disagree with it, you file a notice of disagreement, a nod. You can request a DRO hearing with this if you like, or even an informal DRO conference, which I personally find a lot easier. Um, and then go into the DRO review process. If at the end of that process, the DRO decides that you're right in your argument, they're going to grant another claim and issue a VA ratings decision. However, if they want to stick with their continued denial, what they're going to do at that point is issue what's called a statement of the case. Some folks refer to this as a SOC, others as an SOC, but a statement of the case is something very, very, very particular. And what's important about this is that it starts the first big timeline in the appeal to the Board of Veterans' Appeals. And so you have 60 days from the date of the statement of case to file your substantive appeal on a VA Form 9. You don't actually have to use a form. We'll talk about that in a minute here. But that's what the statement of the case is. And so let's take a look at one. I want to show you what to look at when you get your statement of the case, what's important on this document, and some things that you can kind of look into for some extra little grounds for appeal, and in some cases some very big grounds for appeal. So what I'm going to do is I'm going to pull up a veteran's statement of the case. This one comes out of the Waco Regional Office. It's a fairly old one. We've actually gone forward and had the board hearing on this case. It's all taken care of. What this case is a pretty straightforward single issue claim. The veteran in this case served like I did in the artillery, and as you know, we in the artillery are always exposed to all sorts of loud noises. But this particular veteran was exposed to a grenade explosion, had some ringing in the ears afterwards, and was claiming tinnitus, or as some folks pronounce it, tinnitus. So it's a single issue statement of the case, and I wanted to show you a single issue statement of the case because this document is over 24 pages long for a single issue like tinnitus, which is ringing in the ears. Now, the problem with this is that many of you have more than just one single issue claim. Some of you guys and gals have 15, 20, 25 different issues going on at any given time. And so these statements of the case can get pretty voluminous. I just looked at one that was 65 pages long today. Before doing this, we drafted the VA Form 9. I got that filed. But 65 pages in a statement of the case. So what do you look at when you get this thing? What's important to you? So first of all, let's take a quick scan through this document, and we're going to talk about what it consists of, and then I'm going to point to you some certain things that you should pay attention to. So a statement of the case comes first with the cover letter, and it looks almost all the time, it looks like this. It starts out telling you filed a notice of disagreement, come down here, and it tells you that they've enclosed a statement of the case. Don't confuse that with a statement of the claim, which is VA Form 21-4138, the most worthless form in the entire VA library. You can read about that elsewhere on the blog, but it is totally different from a statement of the case. So you've got this cover letter here, and it takes about 2 pages, usually signed by the service center manager at the time. And then it goes into the actual statement of the case. And you can see up here it's got the date of the issuance of the statement of case. It'll have statement of the case written right up here, and then the regional office that it came out of. You've got the veteran's name right here. I've redacted it as personally identifiable information. Even though I have this veteran's permission to share this information with you, I wanted to redact his name and his file number and social security number. But you should check these to make sure they're right. Make sure that your claim number is the correct claim number, and make sure that your social security number is correct, because we all know that the VA sometimes issues the wrong decision in the wrong veteran's case, or crosses veterans' cases, or if you're a junior or a senior with the same name as the other junior or senior, you're going to have all sorts of confusion in your case. This last block over here, and this veteran was unrepresented. He thought he could take care of it himself. But if he had an attorney or if he had a VSO representing him, it would be listed here. So double check this and make sure that it shows your representative if you have one. Sometimes the VA will change those without you knowing. I've seen quite a few where they've changed from the VFW to the Legion to, well, I haven't ever seen a POA from the Wounded Warriors, so there goes that one. But in any event, just double check this and make sure it's correct. The document goes on to list some, I guess, 18 to 20 pages of legalese, and you can scan through this. We're going to take a little closer look at some of this in a minute here, but it's just basically cut and paste from 38 U.S.C., which is the United States Code section that has to do with veterans benefits. You can see here it's citing to 38 U.S.C. 5103 big A, which is the part of the duty to assist. Also, it will cite throughout here to 38 CFR, the Code of Federal Regulations, the CFR, and you can see a cite to one right here, 3.2600. A CFR is a regulation that interprets a statute. So the statute gets precedence, the CFR comes second in line. If there's a conflict, the statute wins. All right, so we keep scrolling down. This is just a lot of legalese that they've put in here, and the idea is that they think that they're putting you on notice of all the law that they're relying on to decide the claim. But I really want to say what this is, but I'm going to go ahead and say it in a polite way. They've put the kitchen sink in here. If they just go through a computer, they click a bunch of boxes, and it inserts a bunch of code for you. It's largely irrelevant. You can find updated codes and updated Code of Federal Regulations online. And I'm going to tell you how to use some of this if you'd like to stick around to the end of the video. But then you get down to the very bottom of this, and here we are. We're looking at some of the last pages of this statement of the case, and you can see, if we go to our page number here, we're already at page 16. All right, so way down on page 16, we've got our one-line decision. Claim for service connection for tinnitus is reopened but remains denied. And then there's the quote-unquote reasons and bases. And here's where the individual tells a story, and the VA gives their reasons why they're allegedly denying that claim. And we're going to talk about that in more detail. And that's the end of the statement of the case. On the back of this, they should include for you a VA Form 9. You do not need to file a VA Form 9 to file a substantive appeal to the BVA. If you need the citation for that rule, 38 CFR 20.202 is Rule 202. And as long as you have information that sufficiently puts the VA on notice as to what they need in a substantive appeal, whether or not it's on a VA Form 9 or not, it should be appealable to the board. Now, the VA often administratively denies claims when you submit something and it's not on the form they like. So when in doubt, use the form. What I do is I'll put in this little section here in block 10. I'll say, this area is just too small to put my entire argument. See continuation pages. And then I'll label the continuation pages, date them, and sign them all. That way I have more room to make my argument. Don't try to fit your whole argument into here. You're going to be responding to 24 pages or 65 pages of a statement of the case, and you certainly cannot fit it all in this little 3-inch block of text. And then you've got a block for your signature. Here's the instructions for VA Form 9, and here's even more instructions. So if you want to break out your magnifying glass and read those, it doesn't really tell you anything very helpful at all, but take a look at it just to be thorough. So that's what the statement of the case consists of. So let's go all the way up to the top and tell you what, let me get back to page 1 here. I'm going to tell you some things to look at. The very first thing that you want to look at when you get a statement of case is the date. Now, the rule says you have 60 days from the date that the VA mails the statement of the case to file your VA Form 9. Well, what date is that? If you look here on the cover letter, it's dated March 4th, 2013. But if you roll on down to the statement of case, you see that it is actually dated February 28th, 2013. So that's a 4-day difference. I forgot February didn't have 30 days, but that's a 4-day difference right there. And so if you guess wrong, you're going to be 4 days late possibly for your VA Form 9. So the safest thing to do, while I think that that date that's stamped on the cover is probably most likely the date that it was mailed, You can also look to the postmark on the envelope. The safest thing to do is to use 60 days from this date that appears on the statement of the case, because then there's never any argument whether or not you're timely. If you get it within 60 days of this date, nobody can ever say that you untimely filed your VA Form 9. So that's the first thing. The second thing, look here at this issue list here and make sure that all of the things that you claimed in your original claim that were denied in the ratings decision and that you alleged in your notice of disagreement you wanted to appeal, make sure they're all listed here. A lot of times the VA will try to thin the issues by not putting all of your issues in this block here. And you're going to respond to this VA Form 9. If you're like most vets, what you're going to do is you're just going to respond to these issues that they've listed here. Well, little known fact is that the VA Form 9 is what governs the scope of the appeal. Most VLJs at the BVA seem to want to go to this statement of the case, and a lot of times when you get into debates about stuff up at the court, they're going to start looking at this statement of case to see if it's at issue. Well, the governing form is the VA Form 9. So if you look through and you see that, wait, they've only listed this service connection for tinnitus as the issue in my case, but wait a minute, I've got hearing loss, I've got scarring, I've got back pain, everything else, they didn't list it here, included on your VA Form 9. You define the scope of the appeal on the VA Form 9. The next thing you want to look at is this evidence list, all right? And this is basically what they're saying that they relied on in making their decision. So if you all remember, you have a constitutional right to your veterans' benefits. It's a property right under the U.S. Constitution. Because it's a property right under the U.S. Constitution, the VA has to give you notice and the right to a hearing. Well, this list of evidence is part of that notice element. They have to tell you what they're relying on in making their decision. And so what you want to do is a couple of things. The first thing that you want to do is you want to go through and make sure that you have copies of every document that they list right here. Okay, rule number one, where do you get that stuff? Get your claims file. As soon as you get a ratings decision that you don't like, that you intend to appeal, file a request for your C file. Get it. If you're going to own your VA claim, if you're going to take back the power in it, you ought to know what you're owning. So get a copy of your C file. And then you can go through it and run down this list and make sure all these documents are in your C file. If they are not, that means the VA is relying on something that's outside your C file, and that may well be a duty to assist error. Okay, another thing you want to look at is look for things on here that, as I said, are not in your C file. As I said earlier, I went through a statement of the case today. I did a VA Form 9 for a vet, a 65-page statement of the case, and all throughout this was an evidence listing, and it kept referring to these medical documents that weren't anywhere in the C file that the VA had just produced to us. It referred to CT scans, it referred to comp and pen exams. None of these things were in the C file. And so that raises a huge red flag to me because it tells me the VA is looking at something outside the file. Now, it may well be your CMP exam. It may well be your CT scan. It may be your documentation, and you may recognize it as such, but you don't ever really know. I've seen a lot of cases where they refer to exams and other evidence that's not part of a veteran's claim. That's part of another veteran's claim because it got misfiled in this veteran's file. So double check everything off this evidence list. Make sure that it is all in the C file that you have. And then the other thing I want you to do is make a list of things that you think would have helped them make a better decision that is not on this list. Okay, those are the types of things that you are going to point out in your VA Form 9 that are going to form part of the basis of your argument. We're not going to talk about the VA Form 9 here today. The next thing you want to look at is this adjudicative actions here, and this is where the VA summarizes everything that goes on in the claim. And so really what you want to do is you want to match this up with your records, because this tells the board some very specific things. Okay, remember earlier I said to you that the VA Form 9 defines the scope of the appeal to the board. Okay, that's largely true, but you can't add a new issue on your VA Form 9 that wasn't in the claim that you made or that wasn't on the notice of disagreement. So when there's doubt about this, the BVA is going to go back and they're going to look at your notice of disagreement, they're going to look at the ratings decision, claimant notified of decision, and they're going to look at the claim that was filed to see if that issue falls all the way through. So what you want to do is make sure that you have all these documents and track and make sure that you've raised that issue all the way through. And then the other thing is you want to make sure that you've actually received these documents and that they're dated correctly. I've seen a lot of cases where the VA does not use the correct date, or sometimes they mix up dates to make arguments about timeliness and untimeliness look a little bit more favorable to them. All right. Next is this Pertinent Law Section. Um, what I can tell you about this is a couple things. First things, I'm so used to seeing this stuff that I do a quick once over. I make sure that everything looks like it's the normal thing. I'll look at a couple of them just to see if they're actually using current law. But if you really are bored and you have the time, go through each of these paragraphs and compare the site that they're quoting here to the actual current reg. A lot of times, and this sometimes is looking for a needle in a haystack, but a lot of times you can find the VA quoting law that is no longer in effect. And if they're doing that, bang, you got them dead to rights. You can almost guarantee yourself a remand if it's a material piece of law that they're going to rely on that's out of date. So look through it for that. But for the most part, you can scroll through this. You can get a flavor for how the claims process really works if you read it. It's a lot of reading. It's a lot of code. And I'll tell you, the thing about the United States Code and the Code of Federal Regulations is that there's so much case law that interprets this stuff that it's really hard to know what some of these phrases mean. And so I'm going to show you one of those, if I can get to it here fairly quickly, is this Rule 202. And I don't know that I'm going to be able to find it, and I don't want to delay the video. But basically, it's a question of interpretation. So, what really defines competent lay or medical evidence of a current diagnosed disability or persistent recurrent symptoms of disability? What do all those things mean? Well, the cases define that stuff. So you're going to have to do some research if you want to make sure you understand what it means. But then again, I wouldn't worry about this section too much. Just look through it, make sure that everything seems like it's correct. Do a little bit of spot checking to make sure that it's the current law. When you get into advanced claims handling, you can start doing some really tricky stuff like this, like trying to really understand what they're saying in terms of the law, by what law they cite in here. But don't worry about all that. Here it is right here. This is the Rule 202. A substantive appeal consists of a properly completed VA Form I-9. Now, they haven't used I-9 since probably the 1970s or 80s. It's now just called a VA Form 9. So this just goes to show you they haven't updated this code in their software program for at least 2 decades, which tells you something about how old that software is and also how much attention to detail they pay sometimes. But in any event, it does not need to be VA Form 9. It can be correspondence that contains the necessary information. What necessary information do you need? The substantive appeal should set out specific arguments relating to errors of fact or law made by the agency of original jurisdiction, the VA regional office, in reaching the determination or determinations being appealed. To the extent feasible, the argument should be related to specific items in the statement of case and any prior supplemental statement of the case. That's important, to the extent feasible. Okay, it's not feasible to respond to something that the VA did not put in there. So if they're trying to limit the scope of your appeal, put in the condition that you think should be appealed. So we're going to keep scrolling all the way down through this. Get to the bottom here. All right, I want to take you to the next section. This is the decision section. And look at the decision, first of all. Usually it is just a one-liner like this. This is an interesting case because the veteran timely filed a notice of disagreement to a prior ratings decision, but the VA interpreted the notice of disagreement as a new claim. This was when the process for having an attorney help out was fairly new, and I think the VA was getting confused about what some things meant. But in any event, they treated it as an attempt to reopen a claim. You can't reopen something that's not final. So you cannot reopen a claim until that 1-year appeal period has passed. In any event, next thing you want to do, just look at that decision and make sure that it accurately states what they stated in the VA ratings decision, that they're not playing a bait and switch and they're not switching it up on you. And then look at the reasons and bases section. And this is where you really make your money in your claim, because this is where you get to really understand what's going on. The first thing you want to do is you want to go through this section and you really want to understand, why is the VA denying this claim? When I say why, I don't want you to get into all the kind of paranoid stuff that they're out to get you, because maybe they are. Who knows? I don't want you to get into the VA's a bureaucracy that's a flying mess. They can't do anything right. Forget about all that for a minute. What I want you to think about are the four pillars of a VA claim. Are you an eligible veteran? Do you have a service-connected condition? Is there an impairment rating? And is there an effective date argument? Those are the four pillars I want you to focus on. So when I'm looking through these reasons and bases, what I see right now is that, scan through it. Okay, it says that examiner reported a diagnosis of recurrent tinnitus, and based on your statement, we asked for an exam. Basically, what I'm reading through this and seeing is that they're saying that there is no nexus between the tinnitus that the veteran has been diagnosed with and his military service. And so you can see here that they concede the diagnosis because it says the examiner reported a diagnosis of recurrent tinnitus. So that's something I'm going to write down right there. The VA has conceded a diagnosis of tinnitus. That means they can never again argue that this wasn't diagnosed. Now, when you look through the rest of it, you can get the gist of it that they're denying it because there's no proof of nexus. So if you're going to attack this in a VA Form 9, you're going to have to attack the element of nexus. And what's the basis of their decision here? A CNP exam. So what are you going to do? You're going to attack the adequacy of the exam. Did they follow the correct steps? Did they do the right tests? You're going to challenge the competency of the examiner. Is this person qualified to do this exam? And then you're going to challenge whether or not they reviewed the entire claims file. And those are the sorts of things that you are going to challenge. So that's one thing you want to look for in this section. I mentioned it earlier. Look through here for things that the VA concedes. Sometimes they're nice enough to say, we concede. They're not always going to do that. What you're looking for are things where they state as fact what has happened. So right here is a perfect one. The examiner reported a diagnosis of recurrent tinnitus. That's all you need. Now, you never have to worry about having a diagnosis of tinnitus again because they've conceded that it happened. And then the last thing that you want to look through are what I call the goofy little errors. You can go ahead and read through, and I'll show you one right here. All right, here it is. This is a nice one. The examiner noted that there are no complaints of tinnitus or ringing in the ears in the service records, and since you have normal hearing, it is less likely than not that tinnitus is related to the conceded noise exposure in service. Whoop, did not mean to do that. What does that basically mean? This doc is saying, well, your hearing's normal, can't be tinnitus. That's as ridiculous as saying you could not have had a heart attack because you can still walk. The two things are not related to each other. It's irrelevant. So look for goofy things like that. Another one in here is where they say, okay, where did it go? I saw it a minute ago, and it was where he talked about, okay, so this is 10 years after separation is when you made the statement, and that there is no report of tinnitus in the service treatment records. Basically, they're concluding that it's less likely than not that tinnitus is related to that noise exposure because the vet didn't complain or get treatment for tinnitus. And that's horsepucky. I'll tell you right now, it doesn't matter. A lot of us don't get treatment for medical conditions while we're in the military. If half the things that we had happen to us led us to walk into an aid station to get treatment, most of us would never have made it through basic training. The bottom line is you don't seek treatment when you're in the military unless it's something that's got you so you can't walk. Especially if you're in combat, you do not want to let your buddies down by going back to the aid station to have your ingrown toenail looked at while they're up fighting. So the VA can't deny your claim based on the lack of treatment records, particularly when you've got other evidence in the file that supports that something happened or it has a valid reason. Now, tinnitus, you almost never have to prove up treatment, a history of treatment, because there is no cure for it. You can't have ringing in the ears and have it cured. It's going to be there. It's going to be there for life. Sometimes it gets worse. Sometimes it gets better. Sometimes it can cause more problems, but tinnitus cannot be cured. So once you got it, you're stuck with it. So why go get treatment? That's what a lot of folks say. Now, I'm not a doctor. I'm not telling you not to get it treated because it can be an indicator of some other really serious conditions. So if you have it and you have the opportunity to get into a doctor, go in and see a doctor and make sure you don't have something else going on, like a traumatic brain injury or some sort of internal damage to your inner ear structure. But the bottom line is the VA can't hold it against you that you did not get treatment for a condition. But anyway, look through those reasons and bases. This is a nice clean one. It gets a little bit harder when you've got 14 or 15 conditions that you're claiming and you've got another 30 pages of these to go through. It can take some time, and that 60 days to file your VA Form 9 starts to get shorter and shorter the more claims that you have. So when in doubt, come back to places like the Veterans Law Blog and seek out information and seek out help. Talk to other vets, talk to attorneys. If you need help, find a good accredited agent. Find a good attorney that can talk you through some of this stuff. But the bottom line is that's what you want to look at in a statement of the case. That's what you want to be thinking about as you're getting ready to file your VA Form 9. So I hope that helped you guys. This was a long video. I'm going to pop it up there. Let me know how you like interacting with me through the screencasts by using the comments section below. If you'd like me to do more screencasts, I'm happy to do it. There's a lot of things that we can do up here on the screen. I can walk you through benefits. I can teach you all the different documents the VA sends out, what they mean. I can talk you through a lot of stuff, but I got to make sure that you guys like it. So in any event, let me know. Hope this was helpful, and we will talk to you guys later.